The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Court will call the case of, should say cases, Kyle Classic versus Alicia Edzema, 20C 1495 LT. Do you want to enter appearances, or is it the same attorneys on all the cases?
Your Honor, this is Joe Lloyd. I am, I believe, attorney of record in that case. And in the case of Harbor Cove, I think there are other cases in which I am not.
I understand. Actually, your name is on all of these cases, but there's someone named Mr. Biggs with respect to the actual plaintiff in that case. Is Mr. Biggs
Yes, Your Honor.
present?
Brandon Biggs on behalf of Mr. Classic.
Thank you. Case number 20C2456G, Alicia Adzema versus Cheryl Classic. Case, so that one is Mr. Lloyd and Mr. Soteropoulos.
Good afternoon, Your Honor. George Soteropoulos appearing with on behalf of Cheryl Classic.
I do not believe that I'm actually attorney of record there. I don't know if, I don't see Ms. Adzema in court. I think my name was put on the pleadings, but I don't remember that it was me that did it.
All right, let me pull that file. So Lloyd, I have an appearance from you here dated February the 8th or 6th. And it arrived at our court on February 8th of 2021. It is your appearance with your signature.
I apologize, Your Honor. I will get up to speed on that case.
Your Honor, if I may, I think, Joe, the other case involving Kyle Classic that I believe was being removed to circuit court is the one that you're not representing Ms. Adzema on.
You're right. That would be correct. Yes. Excuse me, Your Honor. Yeah.
Let's see.
Makes no mistake.
I have them on all cases. And the one that is the 1495 that I just called, which is the landlord tenant, which had been stayed until removal of the stay by the circuit court. That case has him with a notice of hearing by Zoom, which is an appearance.
Yes.
And that is on July 15th, 2020. So he's on that case as well.
I certainly am, Your Honor. Yes.
Thank you. Harbor Cove Condominiums versus Alicia Adzema, 21C0310.
Your Honor, Adam Randall for Harbor Cove.
Mhm.
And Mr. Lloyd, I think you've acknowledged that you are the attorney on this particular case, and I believe it's your claim of appeal that we're here on today.
Yes, Your Honor. If it pleases the court, this is a hearing on the defendant's motion for stay of enforcement of the court's order of eviction, pending a decision on appeal. As the court knows, you granted summary disposition on June 16th in favor of Harbor Cove. An appeal was filed on June 21st. It's now pending in the circuit court in front of the Honorable Carol Kunke. And this is a hearing on the motion for stay pending appeal. We believe, Your Honor, I have respectfully suggest that the defendant has complied with the court rules authorizing a stay to the extent that the facts of this case allow. The plaintiff, of course, isn't a landlord, and there's no rent in dispute. There have been no escrow order. The plaintiff hasn't sought money damages that would be satisfied out of escrow. There's no claim for money. And the defendant is on public assistance. I had hoped she would be in court able to testify to that, but we have filed application for fee waivers in the circuit court, and I think in this court, and she is on assistance. And let's say she's of limited financial means. In their response to our motion, the plaintiffs suggested that she has no right of possession because of the decision issued by Judge O'Brien on the matter of, I think it was Kyle Klosik versus Alicia Adzima. And that was a case that originally was in this court in front of Judge Pope. And Judge Pope stayed any eviction proceedings in this court. And we note that on appeal, over in the circuit court where they were dealing with divorce matters, the judge was looking at a period of occupancy for 3 to 6 months. But very specifically, Judge Pope's order, if you look at it, says that the stay stays in place until Judge O'Brien dissolves the stay. And she certainly hasn't done that. There's nothing that's been dissolving the stay pending in this court. And what I understand, I am not a party to the divorce negotiations. I understand there are attempts between the parties to try to resolve things. I don't know how those are coming out. But that'll be in front of Judge O'Brien. So to the extent that they're saying that Ms. Adzima just doesn't have a general right to occupy the property, as between her and Mr. Klosik, she certainly does, based on Judge Pope's stay. Now, there could be some action taken in the circuit court to undo that, and that's what I believe they're trying to work out between them. I'm not part of that. But for purposes of what we're doing here today, she certainly does have the general right to be in the property. And for these reasons, I think the interest of justice requires, in order for her complaint to be heard even, I mean, it certainly becomes moot on what I think is an interesting constitutional issue. I know the court decided against me, but I certainly think the issue is worth raising and maybe perhaps hearing on appeal. But that would become moot if she's evicted from the property. And I think in the interest of justice, there should be a stay while we work that out in the Court of Appeals. Thank you.
Thank you.
Your Honor, Your Honor, if I may, if the court wants to hear from me, I represent Mr. Klosik also in the family court matter. I did not represent Mr. Klosik in the landlord-tenant matter. I believe Mr. Biggs did, but I believe Judge Pope's stay was entered in the late winter, early spring of 2020, I believe. We negotiated and a consent order was entered by Judge O'Brien December 7th of 2020, whereby Ms. Adzima consented to be out of the apartment within a period of 3 to 6 months from the date of entry. That was well after Judge Pope's stay was issued, and that was something that Ms. Adzima and her counsel negotiated, and a consent order was entered. So I just wanted to provide some clarity on that. Furthermore, there have been no discussions with myself and Ms. Adzima's family law attorney about extending her stay in the apartment. The only discussion we had as of last week was reviewing child support, and that was it.
Thank you, sir. Mr. Randall.
Your Honor, we have no knowledge about whether or not she's on public assistance because we haven't seen that. We have no knowledge of whether or not the circuit court has waived the fees on appeal because we haven't seen that. We have not at this point sought costs or attorney fees against Ms. Adzima, but she would be liable for them under both the Condominium Act and the Harbor Cove condominium bylaws. We've also read the consent order that was entered on December the 7th, and it said 3 to 6 months. By ordinary time, that would have run out on June the 7th, a full month ago. And so we don't think that there's she independently should be out of the unit. So we don't think there's any harm in issuing an order of eviction now. Or in the alternative, we'd like to see her post the bond that's required by Court Rule 4.201 and 4, bonds on appeal of judgment of possession.
How much do you think that bond is based on the court rule, sir?
I'm sorry, Your Honor?
How much do you think that bond would be based on the court rule, sir?
I have not calculated that, Your Honor.
Thank you. All right. Anything from you today, Mr. Biggs?
I reiterate what Brother Counsel has already emphasized in that this was stayed during the pendency of Judge O'Brien's investigation into the family law matter. Ms. Adzima was given 6 months, which, as keenly pointed out, was a month and a day ago expired. And that was the longest point provided. It was supposed to be 3 to 6 months. And now we are going into, we've passed the 7th and into the 8th month now, Your Honor. And we respectfully concur that Ms. Adzima should be required to vacate the property.
Mr. Biggs, in your particular case, which is the Kyle Classic versus Alicia Adzima, which is a landlord-tenant case, the court in an order on August 4th, 2020, at which time it indicated that the stay in this case was pending resolution of the issues raised in the Washtenaw County Circuit Court case number 19-2600, which the attorneys have referenced here today. And it also said that it would be pending an order from that court dissolving the stay. So at this point in time, there has been that particular provision, I think, is the catch with respect to your case, because there has been no pending order from Judge O'Brien dissolving that particular the stay in this case. And I don't know if that's an oversight with respect to the parties at that circuit court. And I don't think it's a divorce matter. I believe it to be a custody issue.
That's correct. It was custody and support.
I don't see that there has been an order from Judge O'Brien actually dissolving the stay as to that case, which, in some respects, depending on what I do today, becomes a moot point if in fact I don't rule in favor of Ms. Adzima with respect to her stay and the eviction moves forward, unless the Court of Appeals obviously decides to do otherwise. Having said that, I don't know if there's anyone that you have that is involved in that circuit court matter that could address that part of Judge Pope's order. So that's why I put it on here for today, because
Yes, ma'am. We would simply just call the court's attention to the fact that this was in fact a final order entered by Judge O'Brien closing this case, as well as including provisions related to the permissive stay within the condominium, which, as pointed out, has expired. Brother Counsel, who was in fact on that case as well, might be able to shed some additional light on that. But I believe it was simply an oversight of failing to use the word dissolve as these parties entered this consent agreement. But it was certainly the intention of both the parties and the court that this be addressed, as it did close this case, as well as provide for the eventual removal from the condominium, Your Honor.
have there been any proceedings at the circuit court level before Judge O'Brien regarding clarification of the order in terms of whether or not he intended to lift the stay, because it's not part of, doesn't say that.
Your Honor, there has not, and I guess the reason is it can be, I guess it could be viewed as an oversight, but I prefer to view it with, there were 2 attorneys, all parties involved. There was a mediation that occurred. Then there was at a settlement conference, discussions, negotiations, and finality as to when Ms. Adzima would be out of the apartment. And it was by her consent. It was a consent order. that she agreed to be out 3 to 6 months from the date of entry.
I agree with that interpretation. From a practical standpoint, though, we're stuck in a space where we have an order that has not been lifted, and I understand. Judge Pope is no longer present and I'm the judge, so I understand that I can do something about that. I just want to have a full understanding of where we are from the point of view of the attorneys who are actually in that court. With respect to the 2456G case, Mr. Lloyd, I can't help but have noticed that you weren't clear as to whether you were actually involved in that particular matter. But and it appears that it was removed to the general civil court by the plaintiff, which would be you, correct?
And this is the case of her against Mrs. Klosik.
Right. It's the case of her against Ms. Klosik, which she filed in as a small claims matter originally, arguing that Ms. Klosik had not actually repaired the fire damage.
Right. Let's say I haven't given that case. I mean, obviously I wasn't thinking about that case that I had involvement in it. It's clear that I do. And what I want to do is talk with my client and we'll have to see what we can do about that case. But I don't.
Where is your client?
I expected her here. I expected her here today. I spoke with her yesterday, maybe the day before, and she said she would be here. I'm puzzled.
I put all these matters on because I need to get them all in one space to try to figure out how to deal with them all. This is a lot for one family to be going through. And when I say family, I mean there's at least one child that's involved, right? And so
Two, Your Honor.
Yes.
Mr. Lloyd,
Your Honor.
as I read the order from Judge O'Brien, that is a final order and closes this case. It indicates by consent that your client would be out of the premises within 3 to 6 months from the date that it was signed.
It does.
And that takes us to the June 7th date. I'm really having a hard time understanding why we're still here going through all of this.
What I would have expected if this was an order of the circuit court dealing with possession, that they would be trying to enforce it in front of the judge who entered it, who had a better understanding of what the parties were actually doing. I suffer from the fact that suffer's the wrong term, but I have the disadvantage of not having been a party to those negotiations. I'm looking at the order as a stranger, and I think it would be perfectly appropriate. I'm surprised that nobody has thought to bring it back up to Judge O'Brien, but that's not my field of law. I mean, dealing with custody and support and that sort of thing, and I have tried my best to not intervene in that matter. So I would suggest to the court that it's perfectly appropriate for Judge O'Brien to enter an order, and if her order is to move, then she has to move. But right now, I'm, like I say, I don't have the background and the history in that case, and I wasn't a party to the negotiations. And I would be, I'd be really reluctant to start weighing in and renegotiating it here right now. So
I fully understand that part of your position. However, that's only a part of where I'm going with this.
Mhm.
If she has agreed to be out, she is not out. And there is now a new action in which she is the defendant in a case in which this court has reviewed the case law and determined that she needs to be out. And now we're here on appeal, and you're asking me for a stay of what I've believed to be the accurate result of the situation. And you're indicating to me that she somehow is going to be damaged. I'm having a hard time understanding the damages when she's already agreed to be gone.
Well, again, I understood that those negotiations came down in the context of bargaining over child support and not visitation, but Zoom visits or whatever they were doing in those days. And that's the context in which this order was entered. And I'm, if it comes down and Judge O'Brien were to say, no, she's got to be out, I step aside. I've got nothing to say about it. But I don't want to be taking a position on that case when I don't have any background in it. I understand the argument they're making that she doesn't have any rights anyway, but that's a matter on which I think, frankly, Judge O'Brien is the right one to rule. And at that point, then she would not be injured by this, the stay, and the constitutional issue would probably become moot. We'd see. It's an issue that interests me, doing condominium law and such, but if it's moot, it's moot. So, but I would really urge the court to allow the parties to do what they've said they could do, which was just go back and ask Judge O'Brien to either correct the order if that's what they were supposed to do, or readdress the issue, or if she believes that what they intended was to lift the stay down here and have this court enforce it, then that's fine. That's where we are.
Well, the only issue before me right now is the issue with respect to the stay in the landlord-tenant case, in terms of whether or not there should be some clarification from the court as to that. As to whether or not she needed to be out of the premises, I think that order is very clear, that she had 3 to 6 months from the date that she signed that particular order. Giving her the benefit of the doubt, giving her the full 6 months, she should have been out on June 7th. I don't find that there is any damage to her as a result of this particular order from this court, because she's not supposed to be there. In addition to that, the rights that she has are premised on the rights that Mr. Kyle Klosik has in the premises. And with respect to that, she was given the notification that she was supposed to be given, and she still did not comply. I understand that you may have an argument as to that, but I don't think that it requires that this court, at this point in time, stay the proceedings, at least without bond. And that brings me to the issue of bond. You've indicated that she has some sort of public assistance going on. I don't see an affidavit in the file that would indicate.
Your Honor, I believe when I filed this motion, we did not pay a motion fee because there was an application for fee waiver. And so that affidavit, that's what we would be relying on. Now, I can get her to give us details. Again, I'm disappointed she's not here. I am at least tangentially aware of her means and her financial issues, and we can provide the court with an affidavit and details. We'll be happy to do that. But I don't know how she would come up with the money for bond.
I heard you, and I heard your argument on that.
Yeah.
I have in my file a fee waiver request, and the signature on this fee waiver, or there is no signature unless you want to call it an electronic signature, is from you.
That's correct, Your Honor.
Affidavit.
Yes.
So I have no affidavit. I'm not signing it. I have heard your motion. I am not signing that. I have nothing from her. She's not even present. I don't intend to stay this matter without a bond. And so I will now go back to Mr. Randall so that Mr. Randall can help me to figure out what that bond amount should be.
Your Honor, frankly, I've never been appealed on a landlord-tenant possession judgment before, so I'm not even sure what's customary.
I see the attorneys in the breakout session, please. All right, the court has had a breakout session with the attorneys regarding this matter, specifically regarding the amount of bond that needs to be posted in this particular case. The court has decided based on the approximate value of a fair market value for renting this particular unit, that it will be around $1,200 to rent that unit on a monthly basis. Given that the court believes that 6 months of rent would be the appropriate bond in this case, so the court will rule that the bond is $7,200. And based on conversations with counsel, we will give 21 days for that bond to be posted. So the order should reflect that. That is in case number 21C031. I'm sorry. Yep, 0310. In case number 20C2456. Mr. Lloyd, how long do you need to come up to speed on what's going to happen with this particular case? I can give you another pretrial date.
Could you make it a month out, Your Honor?
Let me check the calendar. What time?
You can do 2 or 2:30 or 3.
2 p.m. on August 12th, 2021.
Your Honor, if I may, I'm sorry. I'm going to be out of state and kind of out of the country from August 10th through August 24th. So can we get a date prior to that or after that?
August 26th, is that? We got one at 2 already.
Yeah, 1 and 2, yes.
So let's do another one a different day. August 26th, 2021 at 2:30 p.m.
Thank you.
Does that work for you, Mr. Lloyd?
That'll work. Yes.
And the Kyle Classic versus Alicia Adzima matter, which is the landlord-tenant case. I'm going to bring it back for a status conference to see whether bond has been posted or not posted and what's going on with that part of it. And maybe the attorneys at the circuit court level will have addressed the lifting of the stay. Is it pronounced Sataropoulos?
Yes, Your Honor.
Thank you.
No, amazing, exactly.
No, I'm just going to, that's a different thing. So are you able to come back on that same day for a status conference, sir?
On the 26th, Your Honor? I'm
Yeah.
sorry. Yes, that's correct. Thank you. And Your Honor, if I may, so I take it it was not removed to circuit court as Ms. Adzima had, okay.
It was never removed. It was just stayed, and
Okay. Thank you.
You're welcome. August 26, 2021 at 2:30 PM for a status conference on that.
Sure.
All right, I think we're all set. Correct?
Very well.
Did I
Thank
miss
you, Your
anything?
Honor.
Thank you very much.
Thank you. Have a good day.
You too.
Thanks, Your Honor.
You're welcome, Mr. Clifford. Good afternoon. The 14B District Court is back in session. My name is Elaine Washington, and I'm the judge that is presiding over this session. Court will call the case of Tori Thacker versus Donald Ballard and Kathy Ballard, case number 21C 1436 LT.
Good afternoon,
Oh,
Your
Your
Honor.
Honor.
Good afternoon, Ms. Thacker. Counsel, you may place your appearances on the record.
I'm a student attorney with Legal Services, Your Honor. I'm requesting permission to practice under Michigan Court Rule 8.120 under Lanita Carter.
Thank you. Permission is granted. Hello, Ms. Carter.
Hello, Your Honor. How are you?
I'm well. Today is the day and time that is scheduled for a motion for summary disposition that has been brought by the defendants and their attorneys in this particular matter. You may begin your argument.
Thank you, Your Honor. So the defendants are asking essentially that this case be dismissed, and that's because the plaintiff failed to state a claim, and that's because the notice in this case was inadequate in a number of ways. And so starting with,
Mr. Turbush?
yeah,
I'm sorry. I'm sorry to cut you off. I just realized something. Ms. Thacker has provided the court with a letter that is dated today's date that I believe she dropped off at the court. Have you provided a copy of that to opposing counsel, Ms. Thacker?
I was not, unfortunately.
All right. The court is not allowed to actually take into consideration anything that's not provided to opposing party or opposing counsel in a case.
Okay.
So do you want an opportunity to send that to them so they can review it?
I mean, because I can verbally respond, right?
Not when you file something, you have to give them that same document.
Okay.
Ask her if she'd have to postpone another day or.
Would we have to postpone another day then?
Do you have a copy of the document that you can email them, Ms. Thacker?
Yes, I do.
All right. Let's go off live so she can get an email address to be